and what the Act actually says.
Is the distinction you're drawing because, in your view, CQC were focusing on minimum standards rather than actually bringing up standards across the board?
I think it's about comparisons with their predecessors and the expectations that the public have got. And very clearly for us, it isn't enough to go in, look at what's taking place in some place, pass comment upon it, and then stand back. If there are other means by which you can drive up standards and improve performance. An example I would give you is their predecessor, CSCI, brought out what we consider to be an excellent document talking about domiciliary care and looking at it in its totality about ways in which that service could improve. And I think there's a role for a regulator not simply to be an observer, but also to be somebody who can point to ways in which good practice can be disseminated and improved. And for us, it's important, therefore, that CQC not only acknowledges it's got an improvement role, but they actually see that built into its strategy.
And you would therefore, taking that line of argument, expect them to disseminate nationally, not just regionally?
Yes, indeed. And I guess one of my worries is much of what CQC does is disseminated in media terms at a local level, not at a national level. I have to say, in media terms, I am also concerned that there are times when that organisation uses its resources that it seems to me to manage its image and not actually manage what's taking place. An example I will give you is the Equality and Human Rights Commission late last year published an excellent report on domiciliary care. The day before the report, CQC came out with a public statement about its inspection process for domiciliary care. And I must be honest, I find it difficult to see the value for CQC in doing that, other than to have an impact on the following day's report. And that doesn't seem to me to be its role.
So it's a very serious charge you're putting before the committee. Could I just clarify for my own understanding? What you're saying is that, in your view, to manage its own reputational risk, potentially negative news, which would benefit patients nationally, was not shared nationally, but was actually kept to regional media in order to limit the PR for the organisation itself, or for the NHS as a whole?
I can't comment on the motivation. I can only observe what's taking place. And what I observe is that much of the work is done at a regional level that would be beneficial at the national level.
And precursor organisations like the Healthcare Commission, if that was perhaps doing a report on its national investigations team, which was behind a number of high-profile lessons which the NHS learnt, such as C. difficile, that would have previously have been reported on a national basis.
It would indeed. It would indeed.
So there was a change of direction there?
Yes, most definitely. And we observed that change of direction.
Okay, two people want to ask you. Hang on a minute. Let Mr. Fitzgerald finish. Stephen.
Thank you. Just one of your precursor organisations, the Healthcare Commission, carried out 16 major investigations over a 5-year period. You were set up in April 2009. Between May 2009 until June 2011, you didn't start a single investigation. Did the risk within the NHS change so dramatically during that period?
The risk didn't change, but the nature of regulation changed quite
Well, clearly we can see that from the fact you didn't do investigations. Why was it justified to have such a change?
Because the Healthcare Commission, that was the previous regulator of the NHS, didn't have the powers that CQC has to, as Una O'Brien was saying in her opening remarks. The Healthcare Commission did produce an annual statement about the performance of the NHS, but it didn't have, organisations weren't registered by the Healthcare Commission. It didn't have powers of enforcement in the way in which Una was describing. And so the range of powers that we had are very different to the range that the Healthcare Commission had. We were operating under very different legislation. So our view in the first instance was that we would begin to inspect the NHS. As you have heard already, the NHS wasn't inspected particularly under the Healthcare Commission regime. So we began a process of inspection. We have started a process of enforcement. We have begun to undertake some investigations into NHS organisations, but the powers we have and the way in which we can require improvement by hospitals are very different to the ones.
Would you accept that very important lessons were learnt within the NHS from those major investigations?
Oh, absolutely, yes, indeed.
And it was your decision, supported by the board, to get rid of the National Investigations Team?
In December 2009, the board took a view of how it wanted to deploy its fieldwork staff to take on this bigger role that we'd been given, and it was the decision of the board, I'm not a member of the board, it was a decision of the board that it would abolish a number of central teams and move its resource into frontline inspection.
Sure. And we've heard, sorry...
Recommendation to the board. Was it,
We'd
was it your
undertaken-
recommendation?
Well, yeah, absolutely.
No, don't distance yourself from it. The way boards work is they work from papers prepared by the executive.
So
You agree with the recommendation?
as the Chair refers, it was a recommendation from yourself as Chief Executive. We've already seen evidence from one of your board members who felt it necessary to act as a whistleblower, who said the board is predominantly passive, often being asked to simply endorse decisions. And that was a team that had criticised the Strategic Health Authority that you had led prior to taking on your role as Chief Exec, was it not?
Yes, it was. Well, the investigation into Mid Staffordshire Hospital, which was the main focus of that investigation, that particular investigation, had indeed criticised the SHA and a number of other organisations.
So we have, you were criticised, you then take over the organisation, including staff that had criticised you. You scrap the team that had been responsible for that criticism. I put a named day parliamentary question in for the board minutes pertaining to that discussion, which hasn't been provided even though the deadline's passed. Could you explain why that's
Well, I
the
understood
case?
the board minutes have been provided to you.
No, they haven't. So if the...
Well, I apologise for that, but
Okay.
as far as I'm aware, we've released the board minutes. But I would
look forward to that.
absolutely, the decision to abolish a number of central teams, including the investigations team, was absolutely to do with the change in the nature of regulation that was going to happen in the NHS, and was not to do with a personal agenda of mine.
Sure.
It
Okay,
would
so we've
absolutely
looked...
not engage in anything like that.
Okay, we've already heard about the problems around this registration. There were no investigations done over the first couple of years. Could we come to inspections? It was reported that Parliament was misled with a claim that twice as many inspections and reviews had been carried out than reported in the annual report. Was that the case?
I think that was a typographical error in the report, and that was immediately corrected.
So stating that you'd done twice as many inspections as was the case was just a typo?
As far as I'm aware, yes, it was,
Right.
yes.
But you're responsible for that report. I mean, we're not talking just about a little memo here. I mean, this is the annual report. These documents usually are checked extensively. Any I've been involved in usually go through numerous editions. When was the mistake discovered and when was Parliament informed?
I can't give you that information now, I apologise, but I'm
Okay,
sure we can let you have
I
it.
understand that you've said previously that it was discovered in August, but it was revealed, as I understand it, during the Mid-Staff's inquiry at the end of September, during questioning to Sir David Nicholson. I was just actually wondering, given that Parliament was the body that was misinformed, when Parliament itself was told, or indeed whether it still has been formally told.
Well, I'm sorry, I'm not aware of the actual sequencing of events, and I wouldn't like to mislead you. We can no doubt let you have a note of that.
Okay, perhaps you can let us have a note. You also took the decision to scrap the dedicated whistleblower line that the Healthcare Commission had had. Given what happened with Winterbourne View, where, as I understand it, the CQC was contacted more than once by the whistleblower before he went to Panorama, do you think it was the right decision to get rid of the dedicated whistleblower line?
Well, we established a single telephone contact point for CQC, which is in our National Customer Services Centre in Newcastle. So that's a line that's published for everybody.
That's a general helpline, isn't it?
Yes, indeed, it is.
So you don't
but-
have the experts. If you've got a specialist whistleblower line manned by the National Investigations team, they're going to be far more skilled at picking up the nuances, the importance, the crank calls, which we are all familiar with as constituency MPs, the genuine case from the Maverick. And having a dedicated whistleblower line staffed by people that are used to investigating these sort of issues surely is better, I would put it to you, than having a general helpline of people that usually are dealing with very high volumes of calls. And as we saw with Winterbourne View, fail not once but more than once to pick up on important whistleblower allegations. Do you accept now, with the benefit of hindsight, that that was a mistake?
No, I don't accept that. I think that obviously we have apologised for our failures in terms of how that whistleblowing information was dealt with, but it wasn't that the information didn't get to the right place in the organisation. It did indeed get to the right place in the organisation. It was the inspector took the wrong judgment about how she dealt with that information. I would argue that we do have a dedicated whistleblower team now within the organisation.
Which was set up when?
That does a track and trace.
Okay. And is there not a conflict in, as we've seen with the number of whistleblowers that have come forward, is there not a conflict in a regulator that, as part of its remit, has to encourage openness and a culture for whistleblowers within the NHS that has been signing gagging clauses with its own staff?
Well, can I just go back again to your previous question? I believe very firmly that the systems that we now have in place for dealing with whistleblowing, and indeed the number of whistleblowers who have contacted the organisation since the Winterbourne View events has risen very dramatically. So at least it has raised people's awareness that they can come to us. We now have a team that deal with that.
Can I ask
but
how
even
many
your board...
whistleblowing events have happened and how many of those have been followed up?
Well, we've had since the Winterbourne View, which was in June last year, so since that became published, we've had about 2,500 contacts from whistleblowers into the organisation. But prior to that, we'd had about 200 over the course of a year, so they did go up very dramatically. The team that we've got in place makes sure that every single one of them is now followed up by the compliance inspector.
Okay.
2,500 and 6.
6 people.
Blimey.
The point I was driving at is why you feel it's value for money. That's the remit of this committee, to be signing gagging clauses with your own members of staff.
Well, what we've signed with a number of members of staff are compromise agreements. We don't make any attempt to gag members of staff. Indeed, it would be against the law, the public disclosure legislation, if we attempted to do that, so we don't do that. What we've done is, in a small number of cases, we have signed compromise agreements with staff. These are to the benefit of the staff as well as to the organisation, and we're obliged to ensure individuals get legal advice, proper legal advice, before they sign such an agreement.
But if they're not enforceable in law, why do you need them?
They're about the protection of the individual and the protection of the organisation.
No, it's not. It's about transferring
issues.
legal risk, isn't it? Several whistleblowers felt they need to be subpoenaed by the Mid-Staffordshire inquiry because they were concerned. Even your own board members, if I quote directly from a member of your board, my endeavours to provide robust scrutiny and challenge led to my professionalism being questioned. Doubt was cast on my mental health and my performance. This is someone who, I think for 11 years, was a mental health commissioner who was trying to raise. What does that say about the culture of the organisation you have been leading?
Well, obviously, it is deeply distressing to the organisation that a member of our board chose to go to the Mid-Staffordshire inquiry and has indeed spoken out
It was
in
more
the way
than
that
one.
she has.
It wasn't just her. There was Amanda Bow, I think it was. There was Roger Pollard, who discovered a document, an internal document that you weren't sharing with the committee, as I understand. Roger Davidson, who was subpoenaed. Heather Wood. There's a whole host of whistleblowers that gave evidence to Mid-Staffordshire.
Well, whilst it was absolutely clear, particularly for Heather Wood, for example, where we did indeed sign an agreement, but we made it clear to her that that didn't override any requirement for her to give evidence about any work that she'd undertaken during her time at the Healthcare Commission. So there was no attempt by the organisation to prevent any dialogue with the Mid-Staffordshire inquiry or anywhere else in terms of the use of those, which are very common employment agreements.
Could I, given that I'm out of time, ask one final question to Ms O'Brien? This committee has repeatedly expressed its concern over the use of gagging clauses. In 1999, the Department of Health prohibited them in a circular, and then it changed that in 2004 in its circular. And in the effect of that is, as has been referred, PEDA actually doesn't allow them to be enforced, but what it does is it transfers the legal risk to the whistleblower, and so they are then reluctant to give evidence. Why does the department continue to maintain that 2004 circular?
Well, that is a question that I will want to answer you, but I do not have the background to be able to answer it today.
How many of your inspectors are qualified as doctors at the moment?
Well, we don't keep, there's not a requirement for our inspectors to have clinical qualifications, so we don't keep a national register of what...
Could you provide the committee with a note of a breakdown of the clinical qualifications of the inspectors you've got? What I'm driving at is if you've got generic backgrounds, and I think in 2009-10 you did about 10 days training, partly through workshops and partly through e-learning. You know, if you're going in to inspect doctors, or if you're going into hospitals to inspect and challenge potentially clinically trained staff, how are you going to ensure that someone with a generic background is going to have the skills and the training and the competence to be able to spot what are, in essence, clinical issues?
Well, our inspectors are regulators. They're inspecting against a series of regulatory standards. They're not clinicians. It's not clinical standards in that.
Sure, but you've got to understand the industry you're inspecting.
We do have a range of ways in which when inspectors are going into different types of organisations that they can get professional advice, up to and including joint inspections. So I can think of instances where we've taken surgeons with us to inspect surgery, we've taken midwives with us to inspect midwifery services, so we can bring in clinical up-to-date, current clinical expertise, not someone who qualified 10 years ago, but someone who is currently working in the service, the way we did with the dignity and nutrition reviews, the way we're doing now with the learning disability review. So we take people who are current practitioners in an area, and if we need to take them with us on inspections in order to get a clear understanding of what's happening, we will. The majority of services that we provide are, regulate are in adult social care, for example. We have people with social care backgrounds, we have people with clinical backgrounds, we have people with managerial backgrounds in health and social care, and we have people with no background in the sector. What we are expecting them to be and training them to be are experts in regulation who can draw on additional expertise. So, for example, when we begin to inspect GP surgeries, we will, I'm sure in the first instance, take GPs with us to help us establish the things that we need to start looking at.
Take them away and check it with the NHS pension scheme.
Fine. As the accounting officer responsible as you are for the allocation of funds to
not as a
arm's length
specific point was it drawn out to me. As I say, these are technical details to do with the NHS pension scheme. I'm responsible for the civil service pension scheme.
It just seems one heck of a lot, doesn't it?